My name is Biljana PANTIĆ-PILJA. I'm a member of Serbian delegation. I'm also a lawyer, and I would like to share my opinion about this issue because I think that the law on freedom of religion adopted in Montenegro is aimed directly at the seizure of property of the Serbian Orthodox Church. How else we can describe the disputed provisions of Article 52 and 53 of this law, which stipulate that the property of the Serbian Orthodox Church shall be transferred to state ownership. The law was passed without talking to the Serbian Orthodox Church, which is the only legitimate one to negotiate to the subject. This law is not in line with the European Convention on Human Rights or with the opinion of the Venice Commission. This law suspends fundamental rights, does not respect the principle of religious liberties or freedom of religion, but instead illegally attacks church property. This law is not comparable to any law in the acquis, which contains hundreds and thousands of laws, so much so that it does not even respect the fundamental norms and standards. When it comes to religious legislation, this law is quite unique of the European continent because in addition to the provision on status and registration, it also contains regulations in the field of real law which do not belong here. A modern secular state is a state that is bound to ensure the neutrality of faith and to guarantee us peace, justice, and prosperity. Resistance to this law comes also from people who do not declare themselves Orthodox Serbs. They are massive, peaceful, and non-violent gatherings of all citizens of Montenegro, of all religions and nations, who came together to respond to an unjust and unconstitutional law. This is a state that wants to present itself as a democratic state, not acting as a secular state, but as a state that wants by itself, against the will of churches and religious communities, to regulate not only their legal status, but also their internal character, their nature, and even prevent them from having the right to self-definition. This is a law against the Serbian Orthodox Church and against Serbian identity. In Montenegro, civil, religious, and national rights are endangered. Fundamental civil rights are not respected there. There is no respect for the fundamental provision of the Universal Declaration of Human Rights, which is the right to property. This is where this right is really moved. Article 62 of this law says that the state can seize religious facilities and land used by religious communities. It does not say that they own them, which is actually true, and there is evidence for that, but that they only use them. Likewise, the intention to seize property does not imply any compensation. The burden of proof is shifted to the one from whom the property is seized. It is also something unique and one of a kind. Also, the cultural heritage and its treatments should be governed by another law, the law of protection of cultural heritage and the law of freedom of religion. And in general, its protection has nothing to do with ownership of cultural heritage. For example, if you have a Picasso painting, the state is obliged to protect it, but it may not take away your property. It is also announced that the registrations made in the cadastre of property so far will be considered illegal and null or void, which is against the Constitution. For example, if the property of the church was obtained by a joint venture of the citizens, meaning that the citizens raised money to build a religious facility, and at the same time they did not sign the contract and certified it with the notary, thus making in their property, this particular property will be seized, that is, it will belong to the state. although the recommendation of the Venice Commission is that the procedure for changing property rights needs to be brought before a court. This law, on the contrary, stipulates that this procedure should be an administrative procedure conducted by the cadastre itself, and it significantly contributes to legal uncertainty. This is an extremely bad law, since from the legal point of view, it contains an entire sequence of several branches of law, like real and family law, for example. It simply mixes apples and oranges, I think, really.
Thank you.